Number 8 by Assemblymember Gibson, Assembly Bill 335. Welcome. Welcome, Assemblymember Gibson.
Good afternoon, Mr. Chairman and members. Thank you very much for allowing me to present Assembly Bill 335, the designation of a California Black Serving Institution Grant Program. This bill seeks to establish this program for Black serving institutions to apply for the advancement and equity for underserved students. For context, the genesis of this bill was from our former state senator, Steve Bradford, who authored Senate Bill 1348 in 2024, which laid the foundation for this bill 335 that established the first official Black serving institution designation in the country. As most of us know, specifically, Black students in California and the United States has historically been underrepresented in higher education, and these are students who face a lack of academic resources and support from their college. In fact, the campaign for the college opportunity reports that only 1/3, and I want to underscore 1/3 of Black community colleges students receive a certificate or degree within 6 years. Additionally, according to the survey administered by the California Student Aid Commission, 78% of Black college students in California were food insecure, and 65 were housing insecure in 2023. These are the highest rates of these basic needs, challenging experienced by any group. That is why this piece of legislation is critical for our most underserved students and for higher education institutions that serve those students. This bill that is a representative of California taking a bold approach in supporting communities of color, especially when it feels like their resources are being threatened, not only all around, just all around. Finally, I want to say thank you very much to this committee and the committee staff for working extremely hard with my team in order to strengthen this bill, and also giving me the amendments and suggestions that the amendments are printed in the analysis. So I want to say thank you. And some of those amendments are as follows: setting a base grant for each application or each applicant, and the supplemental grant portion to be determined by the governing board. Strengthening the criteria for grants awarded recipients, including a 25% match for the base grant awardee, and also adding or editing a bill language to remove any obstacles or any part that would be concerning regarding Proposition 209. So I want to again thank the staff for working very closely with us so we won't have any issues moving forward. Proposition 209. It gives me great pleasure to introduce Dr. Keith Curry, the president of Compton Community College, which lies within my district, and also Dr. Teresa Elridge with the Consumer River College, who act as my witnesses. So thank them for coming here in support of Assembly Bill 335.
Thank you so much. Welcome.
Welcome. Thank you. Thank you, Assemblymember Gibson, for authoring this Assembly Bill 335 Black Serving Institution Grant Program. And I encourage the Assembly Higher Education Committee to approve this important legislation with the amendments. As co-founder of Black Student Success Week for California Community Colleges, and in addition to serving as a national chair for Black student enrollment, since 2011, we have seen an enrollment decline in Black students throughout the nation, but also in higher education in California. And the concern it brought us to enrollment is not just about enrolling our Black students on our campuses, it's also about retention and also persistence, and also completion of their degree or certificate from a community college or from a four-year college or university. This bill allows colleges to address the root cause through funding to address the root cause through funding that will impact all students, including Black students at California community colleges and also California State University campuses.
Thank you. Welcome.
Good afternoon. Chair Fong and members of the committee. I am Teresa Aldridge, and I'm a proud graduate of Palomar College in North San Diego County. I bring you greetings on behalf of thousands of underserved students at our colleges that I have personally served during my 32 years service as a counselor in the community college system. I am a mother, educator, student advocate, and faculty leader for over 2 decades of leadership experience in higher education, including my service as counseling department chair, academic senate president, and college union president. Throughout my career, I have worked to ensure that all students, particularly those from historically underrepresented backgrounds and our most vulnerable students, receive the resources and support they need to succeed. I'm here today to express my strong support of AB 335, which establishes the designation of California Black Serving Institutions Grant Program. This bill represents a vital step in ensuring that institutions that serve underserved and Black and African American students have the resources to close persistent equity gaps and improve student outcomes. The data speaks for itself. You've already heard some of that already. Black student enrollment is in higher education declined by 22% between 2010 and 2020, and Black students face some of the lowest college completion rates in our state. As an educational leader, I have witnessed firsthand how systemic barriers, including inadequate academic support, financial hardship, and a lack of culturally responsive services hinder our student success, especially from underserved populations. AB 335 directly addresses these challenges by providing targeted academic resources, mentorship, counseling, and support programs that benefit all underserved students. Let's be clear about what this bill does and what it does not do. The language of AB 335 explicitly states that the grant aims to provide academic resources and support for underserved students and Black and African American students. This inclusive phrasing ensures that the benefits of the program are not limited to a single racial group, but extend to all students who are underserved, regardless of their race or ethnicity. AB 335 aligns with existing educational policy, upholds constitutional requirements, and ensures that state funding is used equitably to enhance student success. This is not an exclusion, it is an inclusion for California as it leads the nation in expanding educational opportunity, and this bill is a continuation of that legacy. We cannot ignore the data. We cannot afford inaction. By passing AB 335, we invest in the future of our workforce, economic stability, and educational success of all Californians. I respectfully ask for your aye vote on AB 335. Thank you.
Thank you so much. Are there witnesses in support in the hearing room?
Good afternoon, Cristina Salazar with Californians Together in support.
Thank you.
Anna Matthews with the Faculty Association of California Community Colleges in strong support. Thank you.
Karen Stout on behalf of the Student Center for California Community Colleges, co-sponsor the bill in strong support.
Alex Sarkisian on behalf of the Associated Students of Sacramento City College in support.
Thank you, Chair and members. Mark McDonald on behalf of the Los Rios, Antelope Valley, Contra Costa, Foothill, De Anza, Kern, San Diego, Southwestern, Victor Valley, and San Bernardino colleges, community colleges, all in support.
Thank you.
Always hard to go after Mark. Hi, Carol Gonzalez on behalf of Long Beach City College and EdTrust West in support of this bill. Thank you.
Hello, Mel Lasseguy for the Greater Sacramento Urban League in strong support.
Good afternoon. Nuna Garipin on behalf of the Chief Executive Officers of California Community Colleges Board in support. Thank you.
Good afternoon. Brian Howe with the California Faculty Association. We just missed the deadline, but we have a co-sponsorship recommendation on this bill. Thank you.
Hi, Kasha Hunt here with Nossaman on behalf of Mount San Antonio College in support, as well as North Orange County Community College District in support.
Good afternoon, Chair and members. Valerie Johnson with the Campaign for College Opportunity in support.
Good afternoon, Elizabeth Betsy Boyd as the chair of the California State University Academic Senate. We have this as a high priority support. Thank you.
Maria Veloz, Los Angeles Community College District, in strong support of this bill.
Thank you so much. Are there witnesses in opposition in the hearing room? You have 2 minutes. Welcome.
Chairman Fong, honorable members of this committee, thank you for your time. My name is Andrew Quino. I'm an attorney at the Pacific Legal Foundation. Pacific Legal Foundation, or PLF, is the nation's leading public interest law foundation that's dedicated to advocating for equality and opportunity for all and fighting against government overreach and abuse. I'm here to discuss what appears to be the unconstitutional expenditure of grant funds on the basis of race in AB 335 that is required of colleges and universities receiving this grant. California has long been opposed to racial discrimination and racial preferences, as demonstrated by its consistent support for Proposition 209 and upholding Proposition 209 in efforts to defeat it or repeal it. As you know, Proposition 209 enshrines in our state constitution a prohibition on government discriminating or granting preferential treatment on the basis of race, sex, skin color, ethnicity, or national origin in public employment, education, and contracting. Meanwhile, the Equal Protection Clause of the 14th Amendment to the United States Constitution does not permit racial classifications unless they withstand strict scrutiny in court. Section 2 of AB 335 violates or appears to violate Prop 209 and the 14th Amendment because it states the following: colleges and universities in receipt of a grant shall expend 100% of the grant to provide academic resources and support to underserved Black and African American students and other underserved students. Allocating educational resources and support on the basis of race, the way that AB 335 currently does, is a direct violation of Proposition 209 and its prohibition on discrimination and preferential treatment on the basis of race and ethnicity in public education. The amendment that has been suggested, in which I understand the author of the bill has agreed to, would now provide that colleges and universities shall expend 100% of the grant funds on academic resources and student support services to underserved students, including but not limited to Black and African American students. This is a less objectionable and less offensive to Proposition 209 in the US Constitution. Though if we are serious about providing additional educational resources to all students, regardless of race, AB 335 should not target any particular racial group and leave it at just serving underserved students. It should not leave colleges with the impression that any one racial group should be singled out and preferred, especially at the expense of others. No college should prioritize any student over another based on race. And there are further opportunities to make AB 335 align with Proposition 209 and the US Constitution. AB 335 should define specifically what an underserved student is, and importantly, that the definition of an underserved student does not depend on an individual student's race or ethnicity. Grant recipients should also confirm that they will not use and have not used grant funds to provide academic resources and student support services on a racially discriminatory basis, and that all underserved students, again, regardless of race or ethnicity, were eligible for these resources and support. The legislature should support and encourage our colleges and universities in expanding opportunities for all California students, regardless of skin color and ancestry. That is in keeping with Proposition 209, the US Constitution, and our tradition of equal, not separate education. I thank you for your time.
Thank you. Are there tweeners in the hearing room?
Good afternoon. Jessica Duong with the University of California. We have a supportive amended position. We just would like to be included in the bill, and we'll take a look at the committee's amendments. Thank you.
Thank you.
Good afternoon. Alex Graves with the AICCU. Would just echo the comments of my colleague from UC. Thank you.
Thank you. Colleagues, any questions or comments? Vice Chair DeMaio.
I greatly appreciate the very logical and precise walkthrough of Proposition 209 that we received from the opponent. There's no shortage of programs to serve underserved students in the state of California. We provide a variety of financial aid packages, a variety of funds, but all those funds look at need, not skin color. Here, we have a very clever but thinly veiled attempt to get around Proposition 209. Voters just recently reaffirmed Proposition 209. The U.S. Supreme Court has repeatedly struck down racial preferences in the allocation of government funds. This is fraught with all sorts of legal peril. You don't put the institutions that you claim to serve in good light. Frankly, I've heard that we still have to figure out which institutions would be eligible for the program. But here you have a bill that is entitled California Black Serving Institutions Grant Programs. The original intent, the clear intent, the unmistakable intent, if we're being candid, is to earmark funds to students based on their skin color. To say that we're going to be giving grants, but they have discretion, I would venture to guess that if they did not give their grant money to people based on the preferred skin color, you wouldn't give them money the following year. And there would be all sorts of people who'd be raising all sorts of criticism. So let's not kid ourselves. Let's respect the vote of the California voters in affirming Prop 209. Let's comply with the law. Let's comply with our state constitution. Let's comply with the U.S. Supreme Court case law as it relates to racial preferences. I urge the author, while well-intended in trying to help students, I would urge the author to perhaps come up with alternative programs to helping the students, not based upon the color of their skin.
Thank you. Any further comments? Assemblyman Saley.
I have some questions. I'm looking at the amendments because I agree with the concerns of the opposition that we cannot have programs based on race, but reading the amendments, it changes the language substantially. It says it's going to provide support services to basically underserved students, including but not limited to Black and African American students. Does that satisfy your legal concerns?
It gets there. It is a step in the right direction. I think as the name itself of the grant program would suggest to colleges receiving this, that there is a specific racial category that is targeted and prioritized. Even if a bill permits a college or university to spend the funds in a race-neutral way, if it appears that the target or the intent is to benefit a specific racial category, that would face some serious scrutiny by the courts and by individuals that may not be benefiting from those grant funds. So the language is a step in the right direction, but I think with an amendment that would clarify and make very clear that this is not intended to benefit or disadvantage a specific racial category, and that an underserved student is not defined based on race, that would go even further and assuage those legal concerns.
Well, let me ask the supporters, because I mean, what it sounds like it's coming down to is the intent. So what is the intent here? What are we doing? What's the purpose? And how will these grants be decided who receives them? If it's not based on race, how will we decide who to award these to?
About the application process.
Whoever wants to. No, yeah.
As written in the bill and also the amendment, there's an application process where you have the governing committee will be reviewing the applications and making a decision based off the grants that was submitted. They also have a linkage to their strategic plan as relates to how they want to improve those institutions and also looking at their data. At the end of the day, we want to change outcomes looking at data, and that's one of the categories that would be involved in the grant is looking at the data for institutions when they start as a Black serving institution to where they want to be in the next 5 years. But looking at the data and have a conversation about the data and implementing program to service through the grant program to improve the outcomes of all students, including Black and African American students.
So is the money, I just want to make sure I understand it. So is the money going to the school, or is the money going to the school and then the school is then going to hand out money to specific students?
It depends on the grant, the way the grant program is written. But the goal for us, when we look at the legislation, is that the governing board will be able to, the managing entity will be able to allocate funds for certain types of grants that's included in the bill, certain areas that they could call out for grants, and the institution submits a grant proposal to the managing entity and to the governing board for approval for funding.
Okay, so are you assuring us that skin color will not be used as a factor in awarding grants to recipients?
What I can assure you on is that we're trying to do what's best for all students, including Black and African American students at our institutions. But it's about all students receiving programs and services, and that's what's going to be included in the grant application.
And it won't be based on race?
We can't have it based on race, based off of Proposition 209.
Great.
So we're trying to follow the law.
I just want to make sure the intent is there. So, did you?
Yeah, I just want to say something. I'm not being disrespectful in regards to the next comment. But at the end of the day, if you look at the data, which Assemblymember Gibson outlined very great today, regards to student success, and you look at all groups as well. But if you look at the numbers for African American and Black students and what has been happening historically in higher education, our goal is to try to fix the problem, the root cause of the problem, and try to provide more support to our institutions to service all students and also African American and Black students. And so at the end of the day, we're trying to do what's best for California, but more importantly, we're trying to do what's best for students. So we want to do what's best for students, and we utilize data to do that.
By the way, I'm not against you on that. I'm with you on that. And, in fact, it's President Trump that secured the funding for historically Black colleges throughout the United States. He's recognized the value those colleges have and that they have not received equal treatment or equal funding. So I appreciate this issue. But in California, we do have a specific law on this. I just want to make sure we comply. By the way, I'm going to ask you, since I have you here, if the bill was based on lineage, for example, if someone was a direct descendant of slaves, would that be constitutional under California federal constitution? I've introduced a bill that would recognize freedmen based on actual lineage. So it's not based on skin color. It's based on whether you descended from slavery or not. Would that hold constitutional challenge?
That's a great question, and it depends on a lot of things. The context, the intent of the use of lineage as a criteria. The Supreme Court has said that ancestry is race, that it can be a proxy oftentimes for race. So again, it depends on the context of why
But not ancestry, it's whether or not you're a direct descendant of a American slave.
Yeah, to me, ancestry and lineage in the use of that in terms of reparations would be synonymous. So you'd have to look at if the purpose is specifically to benefit a particular racial category, and then using lineage really as the proxy, then you're just going to race, and that would receive strict.
But you agree not all Black people are descendants of slaves? American
That's
slaves.
correct.
Yeah.
Yes.
So it would be. Let's just put it this way: it would have a greater chance of surviving constitutional scrutiny than something directly based on race.
Right, and I would refer you again to the Supreme Court case of Rice versus Cayetano. There, the Supreme Court said, even if you have only a subset of a racial category benefiting or having the advantage, that could still come under strict scrutiny.
But it hasn't been tested.
What's that?
I said it has not been tested.
It has not been tested. I don't know if California is going to be the testing ground for that.
Okay.
We would welcome that discussion.
All right. Well, I mean, if we have, this is a committee, this is official record, and we've had their intent on record that it's not based on race, I'm more comfortable with the amendment language as written. So with that, I don't have any more questions. Thank you.
Thank you. Assemblymember Gonzalez.
Just to clarify, I just learned of HSIs, Hispanic Serving Institutions, federally recognized because of the population says that they become an HSI, and then there's, they're open to such things. My question, because I don't know the answer, I need clarity on this. BSIs, is in California, are BSIs federally recognized?
Yeah, so I've done extensive research on this, and it's a very interesting topic, so thank you very much for asking the question. If you look at the minority designations from the federal government, you have several of them, right? So if you look at there's a primarily black serving institution, which is 40% of your population is black or African American. You have the HSI, Hispanic Serving Institution, which is about 25%. You have NIPG, Asian American Pacific Islander, which is about 10%. And so the numbers vary regards to the percentage, and there's also grant programs that are available through the federal government to support those institutions. And so with the black serving institution designation at 10% or 1,500, this is similar to the federal, but it's only the state of California, where's the 10%.
So, and forgive me, I'm just going to kind of go through the process, right? So, yes, they are federally recognized. And so then in California, is there a list of BSIs?
No, not at this moment, because we have an application process
Okay.
that is happening this spring for institutions to apply.
And in this spring, let's kind of push forward. Is there a committee that needs to be formed in order to identify and validate these BSIs?
Yes, so as outlined and signed by the governor on September 27th, the Senate Bill 1348, which is authored by Stephen Bradford, outlines the committee that is responsible for granting the black serving institution designation. And so that committee was established in that bill, and they're going to start meeting this spring to begin that process.
And have they been appointed?
I don't think so.
So the reason I asked that question is, I appreciate where we're going. And like I said, learning about HSIs today, I was like, that's okay, I get that. But if there is Senator Bradford put something and we're supposed to act on it, I guess my question is, why haven't we acted on it? This is not on you, by the way. I'm looking for more clarity as if we're looking for grant money or to establish this and to kind of understand who gets what and so on and so forth. This committee that's supposed to be formed according to law has yet to be appointed. Is there a reason why it has not been appointed that you know of? Because then this would be a moot point if there's no committee to say you get the money. You know what I mean?
Right.
We're missing a piece in the puzzle,
Yeah.
I think.
No, I think because this bill is went into effect January the 1st of 2025, right? And upon the governor's signature January 1st, 2025, I think that the process is being formed and the people have yet to be appointed but will be appointed. And this act as support for Senate Bill 1348 moving forward.
Okay, so you have.
It's in a process.
Got it. And I'm looking at this from a process perspective, right? Not so much of where it's going, who's going to, but have all the steps been accomplished so that action can be taken, whatever that action might be, right? Has action been taken? And it seems to me that there's still action to be taken in this, which is that committee that needs to be formed, because I see it from the HSI perspective that they have the committee, everything, and there's already a process. So I'm concerned with the missing link in this and when, because we know there's some appointments that need to be filled, not only in this but across the board, when and where. So I'm concerned with that process.
Sure, and I would just simply say, Mr. Gonzalez, is that I will do the research and come back with that question directly to your office as it relates to that particular piece, when those people will be appointed and when their first responsibility is going to take place. Because we know if this bill passed and the governor signs it, it doesn't go into effect, of course, until January 1, 2026, because it doesn't have an urgency clause. So I think there's a window, there's a time that Senate Bill 1348 is still in the process of being completed. And by the time that this bill hopefully gets across and into effect by the governor's signature, January 1st, 2026, that would already be completed, and this just rolls right into there.
That would be
Hopefully
the ideal
ideal.
situation, right?
Absolutely.
That would be the ideal situation. And I guess I'm saying this on record that in order for laws to be put into place and things to be successful, such as what you're asking for, we have to take the step back to say, okay, but this hasn't been done yet, kind of what we were talking about before. Make sure that everything gets done so that you can be successful. And I hope that that those who are listening out there can help make it successful by appointing those folks so that we can continue on with the process. Thank you.
Thank you so much. Assemblyman Jackson.
Thank you very much, Mr. Chair. My questions are for the opposition. It seems as though your total opposition is just based upon Prop 209. Is that correct? That based upon that constitutional amendment, basically according to law, your argument is in opposition because the law says you can't do it. Is that correct?
Not only does Proposition 209 say that, but the U.S. Constitution and the 14th Amendment to the U.S. Constitution.
Okay. So the 14th Amendment of the Constitution was passed when?
That was right after the Civil War.
Right after the Civil War. And so right after the Civil War, we had many laws to atone for enslaved individuals, correct? That was strictly for black people. Even after the 14th Amendment was passed, you could even make an argument that many of those that were crafting the 14th Amendment were also ones that also knew that there needed to be atonement to be done, right? And so you had the Freedmen's Bureau that was enacted right after the Civil War that was specifically made for black people because of what the country did to enslave them, to atone for that. And so maybe because of the way courts have evolved, that now you would say that, or many would say that that would be unconstitutional, but it doesn't seem to me that that has always been the case in this nation. Am I wrong in that?
So if you look at the wording of the 14th Amendment, it does not target or advantage a specific racial category. Now, your history is correct, but you'd have to look at the Supreme Court's decision in Students for Fair Admission versus Harvard. There is only two interests where racial classifications may be used: remedying specific instances of past discrimination and quelling riots in prison.
Correct.
What we would have to look at here, if this bill, and the authors have already said that this is essentially a race-neutral bill, but to the extent that it is not going to be a race-neutral bill, then it would have to state the interest in remedying specific instances of past discrimination by the government. It can't remedy general societal discrimination. It's a discussion, again, that's important to have, but does not seem like, given the amendments and the intent of the authors of this bill, one that is necessary, given that the intent it appears to be race neutral. The issue,
doesn't general societal discrimination wasn't its mother overt discrimination and racism? I mean, aren't we just seeing the ripple effects of what has already been done in the past?
Society is very complex, and you can't pinpoint and isolate.
It ain't too complex when it comes to this.
Right. And our Constitution, though, treats individuals as individuals, not groups. So to the extent that the government would like to advantage or disadvantage individuals, they can't do it on the basis of skin color, because that would be treating individual citizens as members of a group, not as individuals.
How is that different from the foundations of this nation?
Again, the plain text of the 14th Amendment does not allow states, or does not advantage or disadvantage, doesn't single out or target specific races. The protection against discrimination from the government or by the government applies to all individuals, regardless of race. I don't disagree with the history you've outlined, Assemblymember Jackson. There's no dispute there. But as far as the 14th Amendment is concerned, as far as the government's obligation under the Constitution, it still cannot advantage or disadvantage individuals based on immutable characteristics like race or ethnicity.
What if a law prevents justice from being done?
tell me more about this law. I think we would have to know more about what.
I mean, we know about all kinds of things that this nation has done to many groups of people, including Native Americans, African Americans, the Japanese people, many people that, Chinese people, right? And they clearly created laws specifically to harm specific groups by race. Therefore, if there are laws in place that prevents us from using those same characteristics that harm was done in order to remedy those harms that were done that was based upon race, I mean, what happens when laws are preventing us from doing that?
Well, then you eliminate those laws. If there's a law that is targeting individuals based on race, saying that they cannot advance, they count an advantage because of their skin color, race, then you get rid of that law. But what you cannot do is presume disadvantage based on race or ethnicity or skin color, because that's not treating citizens as individuals. That's stereotyping.
Well, you can presume based upon harm. And the data of today's society clearly states that. What are the people, look at any list that's good and who's at the bottom of that list, and look at any list that's bad and who's at the top of that list. I guarantee you it's Native Americans and African Americans, right? So you can presume, and the creators of this harm, in their own writings, knew that the tactics that we are going to use will affect these groups of people for at least 100 years. It was their exact intent to do that, and they did it so well that it's working today. Therefore, if a law, do you believe in the concept of an unjust law?
I do, but I don't believe that the 14th Amendment is unjust.
Yeah, well, I would say to you that the 14th Amendment and Proposition 209 is an unjust law because it continuously is being used, particularly against black people, from remedying the harms that we knew existed, that we know was done to us, and we're trying to remedy today, but the progress that we could have had was also stopped by white supremacists. And
Dr.
so I
Jackson,
think
if we
the
can,
idea is that we need to be careful about just doing this altruistic
Dr.
Prop
Jackson?
209. Thank you, Mr. Chair.
Thank you so much. Thank you. Any further comments for the author, colleagues? Mr. Mersucci, thank you.
I just want to thank our colleague from Compton, and I'd be honored if you'd add me as a co-author to your bill.
Thank you.
Thank you so much.